Good morning, everyone. In this session, we will analyze a legal scenario dealing with non-fatal offences and liability. We are going to analyze some four scenarios. This video serves purely as an informational and educational resource. We recommend reviewing their full disclaimer carefully. Let's start with the problem question. Consider the legality of the following activities in which injury is caused. Deliberately fouling a player in the football in order to prevent them from scoring a goal. Second scenario, kicking a person in the face in kickboxing. Third one, a body artist cutting a client's ear off at their instigation in honor of the painter Van Gogh. Fourth scenario, gouging deep scratches on your partner's back during consensual lovemaking. And the final one, punching a friend hard in the stomach during play fighting. How far, if at all, does the concerned provide a defense to potential non-fatal offences liability in these situations? Before moving to each scenarios, the defense of concern plays a crucial role in determining whether an act of violence can be legally justified. However, a concern does not automatically negate a liability for non fatal offenses. If the act is deemed to be outside the bounds of socially acceptable behavior or contrary to public policy. Under Section 18 of the Offences Act, the against Offences Against the Persons Act 1861, Section 47 of the same Act, and the case law, such as Orr versus Brown in 1993, concerned can be a valid defense in specific circumstances, but is generally not available for acts that go beyond socially acceptable contexts. The following analysis consider the legality of each of these activities mentioned in the question. First, when we start with deliberately fouling a player in football to prevent a goal. In football, the fouls are common and can often result in injury, but they are typically regulated by the rule of the sports. The question of concern arises when an injury resulted from an action that fall outside the boundaries of the game's rules. Concern may be implied in the context of the sports, as in Orr versus Barnes case in 2004, where the court held that the participant in the context sports, such as football, generally concerned to a degree of physical condition, physical contact, and risk of injury, as long as it is within the rules of the game. However, deliberate fouling intent to cause injury, particularly within the intent to prevent a goal, may go beyond what is socially acceptable and could result in criminal liability. In such cases, the defendant cannot rely on concern, as the act would not be deemed within the scope of what the victim has consented to in the context of the sports. In other words, in football, as in the other sports, there is an implied consent to certain level of physical contact, including fouls, tackles, provided these are in line with the rules of the games. In Orr versus Bonds case in 2004, established that injuries caused during the competitive sports are typically considered lawful as long as the contact falls within the accepted rules and the context of the sport. However, a deliberate foul outside the rules to prevent a goal, such as tripping or causing injury intentionally, may not fall within the scope of implied consent. In Orr versus Brown case in 1993, the courts were clear that activities that are deemed contrary to the public interest, such as intentionally causing the harm or the injury, are not shielded by the consent. If the foul was deliberate and the outside of the context of fair play, concerned would not likely provide a defense. Thus, in this case, the deliberate foul would likely not to be protected by the concern as it is outside the rules of the football, making it potentially unlawful. Second scenario, kicking a person in a face in kickboxing. In regulated sports like kickboxing, the rule of sports allows for the central level of physical aggression, including kicking, punching, and other options that could cause injury. The concern is implied in the context of such activities, as participants agree to engage in the sports with the understanding that injury might occur. However, the defense of consent would not be available if the injury caused exceeds the acceptable limit of the sports. In Orris Aitken, the court upheld a defense of consent in case of consensual injury during the acts such as military hazing, as long as the act falls within the acceptable boundaries. If, however, a kick to the face in the kickboxing is delivered with excessive force outside the agreed rules or in a non-competitive context, concern would not provide a valid defense, and the act could be prosecuted as a non fatal offense under the offenses against the person acts. In other words, kickboxing is a recognized sport where the physical injury is expected as part of the contest. In such regulated sports, participants generally consent to the level of injury that is permissible within the rule of the sports. In case of R versus Bonds, 2004, established that injuries occurring within the accepted bounds of the sport, even if contrary to the rules, may not result in the criminal liability. Kickboxing, like boxing, is an activity where the contact, including kicking, is expected and permitted within the context of the sports. Therefore, as long as the act of kicking the person in the face is within the agreed upon rules and is done during the course of the fight, concern would provide a defense. However, excessive force or actions outside the established rules could lead to a criminal liability. For instance, a kick that exceeds the normal contact of the sport, especially if it involves intentional harm outside the contest limit, would not be covered by the defense of consent. Third scenario, a body artist cutting a client's ear off at their instigation in the honor of the painter Van Gogh. In this case, the act of cutting off a client's ear, even if done with the client's consent, raises significant legal concern. A concern to injury is generally not a defense to acts that are deemed to be dangerous or contrary to the public policy. In RSS Brown case 1993, House of Lords ruled that the concerned does not provide defense to acts of violence that are not in public interest, such as in sadomasochistic activities. Cutting off a body part, even with the concern, would likely to be viewed as excessive, and it is contrary to the public policy, as it involved the permanent harm and a risk of serious injury. This type of injury is outside the socially acceptable bounds, and the body artist would likely be criminally liable for causing the grievous bodily harm, even though the act was consensual. In other words, the act of cutting off a client's ear would not be protected by the concern. A body modification, so outside of the medical procedures, has been examined in the court, notably in R versus BM case in 2018, where the body modification was not regarded as lawful, even if the victim consented. The court held that consent is not a valid defense where the injury caused is considered to be contrary to the public policy or the societal norms. In the case of body art, cutting off a body part, especially in the non-medical context, would likely be deemed contrary to the public interest and outside the scope of law concerned, as in R versus BM case. While tattoos and piercing may be lawful forms of body modification where injury is reasonable, cutting off an ear is more extreme and falls outside what is considered acceptable, even with the concern. Therefore, the defense of consent would not likely apply in this case. Fourth scenario, the goofing deep scratches on the partner's back during consensual lovemaking. The act of violence during consensual sexual activity often raise questions about the limits of consent. In R versus Brown case 1983, the House of Lords held that concern could not be a defense to acts that cause serious bodily harm in a non-socially acceptable context, such as in the case of sadomasochistic practices. However, Section 58 of the Sexual Offences Act 2003 provides that a person is not guilty of sexual offense if they reasonably believe that the other person concerns. The line is drawn between what is deemed acceptable, such as mild scratching or the playful activities, and the actions that result in serious injury or harm. A deep scratches that causes substantial injury may be seen as going beyond what a person could reasonably concern to in the context of sexual activity. If the scratches are superficial and do not result in permanent injury, a concern may be a valid defense. However, if they result in permanent damage or the pain, it could be seen as a non-fatal offense, such as actual bodily harm, where concern would not absolve the defendant. In other words, the situation concern the sexual activities where the physical injury occurs. The defense of concern in sexual context is often discussed in cases involving injury, as seen in R versus Brown case, where sadomasochistic practices involving the injury were not upheld by the defense of consent, as the activities were deemed to be contrary to the public interest. However, in situations where injury is minor and the act falls within the bounds of the consensual sexual activities, the courts are generally more lenient. In R versus Slingsby case, the courts ruled that the consensual sexual activity, even if it is resulted in injury, such as a minor tear, could be lawful. The decision hinged on the fact that there was no intentional harm and the injury was incidental to the sexual act, not part of an unlawful activity. However, if the injury is excessive or the circumstances involve conduct clearly contrary to the public interest, as in R versus Brown case, the concerns may not be a valid defense. In this case, if the scratches are relatively minor in the part of the consensual lovemaking, they may fall within the bounds of lawful consent. But the excessive injury may lead to a criminal liability. The last scenario, punching a friend hard in the stomach during the play fighting. A play fighting is generally regarded as a situation where consent can be implied, particularly in the context where there is no intent to cause harm. In R vs. Jones case in 1986, the court held that in situations like play fighting, consent may be valid if the victim willingly participates and the actions do not result in serious harm. However, if the punch is excessive or cause injury such as breaks the ribs or internal injury, the defense of consent may not apply, and the defendant could be liable for battery or ABH, depending on the severity of the harm caused. The key factor is whether the level of force used exceeds the social acceptability of the activity, as seen in R versus Aitken case in 1992, where the court allowed the concerned as a defense for minor injuries in consensual rough activities, but did not extend it to more severe harm. In other words, a play fighting is a form of horseplay where both participants concerned to the physical activity, and the courts have generally upheld the consent in such cases. In R versus Jones case in 1986, the Court of Appeal ruled that consent could provide a defense to a charge of assault in the case of horseplay or the rough play between the friends. The key issue is whether the conduct was within the bounds of what is reasonably accepted as a play, whether the injury caused was unforeseen or excessive. In this case, a punch in the stomach during the play fight may be considered out of the grain, as long as both parties considered and the injury was not serious. The defense of concerns would likely apply. However, if the punch excessive or it causes serious injury, such as internal damage or a risk to the health, the consent of defense may not be available, as in R versus Aitken case in 1992, where the court found that certain injuries in the context of the play fighting could exceed what was acceptable. To conclude, the concerns may provide a defense to the non-fatal offenses in certain circumstances, but it is subject to limitations. In sports such as football, kickboxing, consent is implied to the extent that physical contact is part of the game, as long as the contact is within the acceptable bounds of the sports. However, deceptive acts such as body modifications or impersonations or the acts involving injury that is clearly contrary to the public interest, as in the body out or the extreme injury in the sexual activities, may not be protected by consent. For play fighting, the consent is likely a valid defense as long as the context remains within the reasonable limits. Ultimately, whether the concerns provide a valid defense depends on the context, the severity of the injury, and the public policy considerations of the activity. The availability of the defense of consent is limited by the needs to ensure that the act remains within the socially acceptable bounds. In cases like play fighting or regulated sports, consent may provide a valid defense as long as the injury caused is not excessive or out of proportions to the context of the activity. However, the case involving the serious or permanent injury, such as cutting off a body part or goofing the deep scratches, the concerned is unlikely to provide a defense, as these acts fall outside which is considered socially acceptable. The law carefully balances the rights of individuals to engage in activities involving the risk with the need to protect the public health and safety, as shown in the cases like R versus Brown and on R versus Jones case. Thank you.